Hello everyone. Hello everyone, and welcome back to yet another session on polity and constitution. Good evening, everyone, and welcome back to yet another session on polity and constitution. I hope I'm audible as well as visible. Rainy day. Femina. Rainy day? Are you in Kerala or what? Where else are we having rains? Oh, Maharashtra, Punjab, Indore also. Great. Gujarat. Oh, amazing here. It's raining in Srinagar. Which edition in the Hindu to read? Any edition is okay. Whatever edition is available to you. In Bangalore, I don't think it's raining in Bangalore. One thing I can guarantee. Yes, Magesh, allowed to avail the benefits of Nalsa. Oh, acha, Hassan, it's raining. Okay, possible. Lavanya, what does it mean? What is your question? Okay, so great. It's raining all across the country, I feel. I mean, emotional rain or actual rain, I'm not sure, but Nutan, so it is mandatory to reside in Rashtrapati Bhavan for president and Raj Bhavan for governor. Not really, not mandatory. But if you are given the opportunity, why would you not reside there? Sarufuddin, any edition you get your hands on, it's the same thing. The local news changes. Otherwise, the other news is the same. High Court jurisdiction cannot be curtailed. Why can it not be curtailed? It can also be curtailed. Shalu, 30 days. Preetham, if you follow the newspaper consistently, you'll find that maybe there are some articles which are published, say, here or there, depending on also local influence. So it is subject to slight modifications. Otherwise, there is not much difference. It is not that the Delhi edition is amazing and UPSC paper setters are reading from Delhi edition only. Because UPSC paper setters are not residing in Delhi only. They are all across the country, right? So there is no single team which sets the questions. Multiple people from various universities are asked to prepare questions, and questions are chosen from that, a draw of lot kind of a system. So it is of, I mean, I don't think it's of great help that you read the Delhi edition. It won't be any difference actually. Vaishna, you will always submit your resignation to the person who appoints you. Did you get your answer now? You will always submit your resignation to the person who appoints you. So Vaishna, tell me now, what is the answer to your question? No, Sneha, that is not experience in Supreme Court. Gurjeet, here no newspaper comes. It would come one day late. That is possible. Or online edition, read that. Okay, so people have joined now. let's do a quick recap. So in the previous class, that is yesterday, we saw Supreme Court, the oath, salaries, Article 124, Clause 7. We saw all the other provisions pertaining to, court of records, ad hoc judges, retired judges, the seat of Supreme Court, and various kinds of jurisdictions of the Supreme Court, including, the original, the appellate, so on and so forth. Then we saw high courts, and then the structure of the subordinate judiciary. Okay, so that is all that we saw yesterday. Apart from it, one small topic, NALSA, and towards the end we discussed the need for judicial independence and also reasons for judicial independence. Okay. Kausar will discuss your question in say half an hour. What is the reason for pendency? Anand Padmanabhan, you can simply go to Delhi and file a case in Supreme Court, hire a lawyer, and the lawyer will file a case for you in Supreme Court. That's how you file a case in Supreme Court. Okay. So now let's begin our discussion. But before that, 5 questions you know very well. Starting with the very first question. "45 seconds time to mark the answer." Okay, a lot of you mark this correct. There is no fixed tenure. Is the tenure of a judge in the Supreme Court fixed? Of course not. The retirement age is fixed, but for how long? Not fixed. So of course one is correct. And the conduct of the Supreme Court judges, we know very well, it cannot be discussed during in the legislature. Only case will be if he is being removed or impeached, then the conduct can be discussed. Otherwise, it is a breach of parliamentary privilege. You cannot discuss on the conduct, the behavior of the judges. You cannot pass comments on the behavior of judges in the legislature. Both are correct. C, both 1 and 2. Moving on to the second question. Okay, others, what is the problem? What is this issue? Read the third statement. Salaries, allowances, and pensions of judges of both Supreme Court and High Courts are charged on CFI. Come on. The pension I had specifically mentioned is not charged on the charge on CFI, but the salary comes from CFS for the High Court judges. So yes, the pension comes from CFI, but the salary is given by respective judges of the respective states where the judges are appointed as High Court judges. So 3 is wrong. Let's remove 3 first. Okay, this is gone. Number of judges in the Supreme Court can be increased by Parliament. Is it not correct? Number of judges in the High Court can be increased by President. Is it not correct? 1. 1 is correct. Let's check 4 now. The advisory jurisdiction of the Supreme Court has to preside over by minimum 5 judges is also something we saw. C. And this is also correct. Removal process is exactly the same. Pretty easy question, but very less students mark this correct. Okay. Anyway, moving on to the third question. Okay, fair enough. A lot of you got trapped. Tell me, what is the problem with the first statement? Oath and affirmation is mentioned where? Not in the second schedule. It is in the third schedule. Okay? I solemnly affirm. So 1 is wrong. 2 is correct. B, 2 only. Fourth question. Okay, a lot of you got this correct. The judgment of Supreme Court, the judgments are recorded for perpetual. Perpetual means uninterrupted memory, forever. This means what? Court of records, their judgments become facts. It's just another way of expressing the same idea. Perpetual memory, forever. The Supreme Court has the power to punish for its contempt. Of course, 2 is correct. C, both 1 and 2. And last question for the day. %42 got this correct. Consider the following statements. The High Court judges on retirement are debarred from practicing in the Supreme Court. No, they are not debarred. This is a wrong statement. They're allowed to practice in Supreme Court. Okay. Violation of the Constitution is the only ground. No, the ground for removal is not violation of Constitution. The ground for removal is misbehavior or incapacity. For which person is the ground for removal violation of Constitution? Please tell me. Which person? Okay, the President. Absolutely correct. So both are wrong. Hence, D should be the answer. But they are asking incorrect. So C will be the answer and not D. Okay. So that's there. 5 questions for the day. Now we'll move on and understand about the judicial issues, primarily pendency of cases. Yes, leaderboard, don't worry. Oh, people who have scored full 5, I'm sure they won the leaderboard. Okay, this is the leaderboard. Roshni, Amardeep, Gopal, Saloni, Jagdish, Sneha, Nitesh, Sairaj. All 8 of you getting all 5 correct. Then Anayat, Kausar, Candy, Satyaprakash, Ravi, Shobhit, Anushka, Abhishek, Ashwani, M. Narendra, Tanu, Wahid, Balasai, so on and so forth. 4 correct. Okay. That's it. So this is there for today's practice questions. Why leaderboard? Yesterday you wanted a leaderboard. Today somebody else wants a leaderboard. Whoever scores all 5 wants a leaderboard. Others say, why leaderboard? Okay, let's begin our discussion for today. Issues concerning judiciary, starting with the very first issue, pendency of cases. Okay. So, pendency. What is the meaning of pendency? Pending cases. Pendency of cases, for those who do not know, pending cases in the courts. So, firstly, is that really a big problem? I mean, in such a vast country like India, for that we have to also see what is the extent of the problem. So, some facts are required. How many cases are pending after all? If 50 cases are pending, no problem. So, in the Supreme Court, it is around 70,000. This figure keeps on varying. I'll give you the current figure, 68,847. These are the pending cases in the Supreme Court. In the exam, just write 70,000, around 70,000. Then High Courts. In the High Courts, we have over 60 lakh pending cases, 60.75 lakh pending cases. And in the subordinate courts, the lower courts, it is a mere 4.33 crore pending cases. Okay. So, which brings the total pendency in the country to roughly 5 crores, 4.95 crores, right? Slightly less than that. I mean, it has, I think the rough figure was 4 crore 94 lakh something. So 4.95 crore cases pending across the country in various courts. That is as good as 5 crore. Simply say 5 crore cases are pending. Not just this. If you look at how many cases are pending for more than 30 years, pending for over 30 years. So this figure also is almost 1.8 lakh. So there are 1.8 lakh cases which are pending for 30 years. Almost 72,000 cases in High Court and around 1 lakh 6 or 7,000 cases pending in the Supreme Court. The exact figure is 1,79,000 cases pending in the High Courts, pending in the courts across the country. 1.8 lakh cases, 30 years. Where is the justice, right? Not just this, even if you see something as basic as pending for over 3 years, in high courts, all the high courts, around 64.4% cases are pending for at least 3 years. In the subordinate courts, roughly 45.36% cases are pending for over 3 years. So this is with respect to the pendency of cases in our country. And just to know, XY, my Nanu's case started in year 2002 when I was born. It is pending until today. Don't worry. When I teach polity after 20 years, your kids will also say the same thing. That my great grand Nanu's case started in 2002. It is still pending. This is the situation of our Supreme Court, High Courts and all. Anyway, just to give a very interesting piece of anecdote, in this case of Niti Aayog, so Niti Aayog had published a report on this pendency. 2018, they published a report. They had said that to clear the backlog, meaning pending cases, if we stop people from filing any kind of case now, and we only focus on clearing the backlog, it will take, the backlog will be cleared in just 324 years. 324 years. This is when the total pendency was just 2.9 crores. Today it is 5 crores. So you can very well understand the seriousness of this issue. That pendency of cases is a very serious matter. Okay. So this is with respect to pendency of cases. And now coming to this big concern, what is the problem if there is pendency? What happens? Of course, you will say, sir, justice delayed is justice denied, right? So that's of course there, without doubt. See, when it comes to adverse implications, interesting point to note is that Supreme Court says where there is dharma, there will be victory. Where is the dharma? There is no dharma here. Yato dharmastaho jaya. Where there is dharma, there will be victory. Anyway, if there is too much of delay in the delivery of justice, it is not justice after all. We have seen situations where somebody has been jailed, is in the jail as an under trial. Who is this person called under trial? Do you have any idea of what is this person called under trial? Tell me. high under trial population. Under trial is somebody who is in the prison but is just an accused. He is not a convict. He has not been held guilty. It is just that the date was not given to him and his case is pending in the court, but bail has been denied to him and he or she is in the jail. That person is called under trial, right? In one case, it was found that this person was sitting in jail for almost 12 years. When his case came for hearing, the court realized that the maximum punishment that could be given in his case was only 6 months for the crime he had committed, and he was in jail for 12 years. The court with folded hands said, extremely sorry. And the court also, I believe, granted a huge compensation of 25,000 rupees to the person. Okay. So that's such a huge amount for 12 years of life. Of course, we know very well, right? I'm not sure what this person did with 25,000 rupees. Should he purchase some property in Dubai or should he go to Mars from that huge amount of money? But that is how it is. Anyway, if you look at the total prison population, we have roughly, in 2021, the data that we have seen from NCRB, we have around 5.55 lakh people in the jail, out of which 77% are under trials, meaning in the entire jail population, less than 1/4 people are actually convicts, right? They are in jail, waiting for the date to come, waiting for the my lords to deliver justice eventually. Then it also wastes resources of the judiciary, giving dates again and again, case pending, wasting resources of the litigants. That's also there. Then erodes the erosion of image and credibility of the judiciary. The credibility and image of judiciary, it gets eroded like soil erosion. It gets removed. Of course, people stop having faith in the justice system. So that's there. And when people stop having faith in the justice system, then they tend to employ extra legal means or even commit crimes, because they know very well that if I commit a crime, my case will be heard in say 15-20 years. What's the point? What's the problem? Till then enjoy, right? So, and they tend to employ extra legal means also. For example, think of this. All these government banks, when you take money from these government banks and don't repay the loan, they will file some court case, etc. And the case drags on and on, right? But think of these private lenders. These private lenders, when they lend you money, they will not go to court and file a case. They know very well, if I go to court and file a case, it will take years for me to collect the money. They will hire some protein powder fed people, the bodybuilders, and they would come to your house and will treat you very nicely, and then you'll give 4 or 5 EMIs in advance only. So what is that? Because I believe that the system will not help me, so I have found extra legal means which I am employing to get my task done. So this is with respect to adverse implications, right? So this is these are some of the issues. Now, coming to reasons for pendency. What are the reasons for pendency? So this is Mr. Amitabh Bachchan saying that, please don't look at me. I cannot be of any help to you. I think that is what judiciary also says to the Indian people. that sorry, please find some other way. I may not be of help to you. Anyway, what are the reasons for pending cases? Please write reasons. Vacancy, less judges, vacancy, less judges, vacancy, holiday, vacancy, tariq pe tariq, vacancy, governance issues, evidence is not available, slow process, corruption, less number of women present, poor infrastructure, so many cases. So many cases can't be a reason. Give me reason for so many cases. Okay. Political pressure, no proper evidence, lack of judges, vacancy, inadequate funding, slow process. Okay. Reason number one, as all of you have pointed this out, that the total sanctioned strength is very low. Total sanctioned strength is very low in the country. In Supreme Court, how many judges? 34. In High Courts, how many judges? 1114. In the subordinate courts, how many judges? So you saw yesterday around 25,000. 25,129. This is what is the number of judges that we have, right? So of course, if you add all this, it will come down to 26,777. 26,277. Total 26,277 judges. Compare this to a country like China, where they have 2 lakh judges. How is it fair? Now, apart from this, India's population is very high. The most populated country. The award has finally been obtained by us. Untiring efforts of our people in this country, right? Because of that, now we are the most populated people in on this planet. Okay. Anyway, it's no mean feat, an achievement. What can we say? But because of that, the judge to population ratio is also very low. Less judges, too many people. So if you again use this idea, in our country, how many judges do we have? We have 26,277 judges, roughly 142.86 crore population. So if you divide that, that will come to slightly above 18. This figure could be somewhere close to 18.4. 18.39 or something. 18.4 judges per 1 million people. This is the judge to population ratio. Right? So this is there with respect to a very big problem. Now, to top it all, we have lesser number of judges, too much of population, and then we have vacancy also. I mean, vacancy, look at the vacancy in the high courts. See, as of now, you can proudly say in Supreme Court, there is no vacancy. It is a rare situation and occasion where we have no vacancy in Supreme Court. At least from the time I have been teaching, this is the first time that we have zero vacancy by chance also in the Supreme Court. But very shortly, a couple of judges will retire in the next 2 months. So we'll have some vacancy. But in the high courts, this figure is 331. 331 out of 1114. That is around 30%, right? Or look at even the subordinate courts. There also you have vacancy of over 5,000, 5,750. This would B5750 22 88. This is roughly 22.88%. Rough estimate. This is the number of vacancies. I mean, the real problem starts here only. That we don't have ample number of people and too many people in this country filing cases, which gives rise to pendency. Apart from it, now we also have one very now an issue which should not be solved. This issue is increase in literacy levels. So more literate the country, more civil cases people will file, right? Just to give you an example, in Tamil Nadu compared to say Bihar or Jharkhand, roughly 12 cases are filed for every 1,000 people, civil cases. In Bihar, Jharkhand, it's 0.5. So in those states which are where the literacy rates are higher, more civil cases are filed. In fact, India is no match. India is no match to the number of cases being filed in some Western countries. In India, for every 1,000 people, around 17 to 18 people file cases. But in countries like USA, this figure is 330. Imagine if we start filing cases like the Western countries, right? So, which will happen when we become more literate, when we become more educated, more aware of our rights, we'll file more cases in court to get the government and other people to follow rules, regulations, which will mean only increase in the pendency. That's there. Then, one more interesting point. You know how many holidays Supreme Court has in every year? Supreme Court enjoys summer vacation, like a small school kid, 1.5 months. Supreme Court enjoys winter vacation. Supreme Court enjoys 5 days of Holi, 5 days of Diwali, right? So, just to give you a summary of the number of leaves, lesser sittings in courts. For example, in 2023 also, Supreme Court will only have 190 working days. That's it. Okay, so, and I hope now you understand. All those people who work in some private company, they would understand this value of this meme. Holiday or leave in a private company is a dangerous thing. You have to look at the mood of the boss, right? And then ask for a leave. And we have seen situations where people are working even during their marriage going on. They are still attending some online meeting, etc. And here we have just 190 working days right now in 2023. Last year, it was 174 only. Okay, that's there. Yes, Shalu, Saturday, Sunday holiday for Supreme Court. We have just a sec, guys. Okay, so that's there. Then some more reasons. One more thing is the very poor quality of our investigation and prosecution. Poor quality of investigation, prosecution. So we know our police are so highly efficient in collecting evidences that in most situations when they go to court, the only thing that they want is more time. Why does the court give adjournments? In most cases, adjournments are demanded by the police only. Sir, more time please, more time please. We don't know what they're doing, right? So that's there. And of course, if you really want to know the quality of our evidence collection, there's a very interesting movie based on a book, based on a real story called Talwar, directed by, I think, Meghna Gulzar. You should watch that movie, right? And also, I think a lot of police procedural movies are being made in the Malayalam cinema, starring Dulquer Salman or other people also, which showcases that evidence collection is slightly shoddy on the side of the police. Okay, that's there. Then one more problem: too many adjournments, reservation of judgment given by the courts, excessive adjournment. What is adjournment? Case is adjourned for the next hearing. And it is very, very easy to get an adjournment. This particular photograph, for those who do not know, is from a 1990s, early 90s movie called Damini. Early 90s. Some of you were not even born when the movie released. And here, this actor, Sunny Deol, says the court only gives tariq, date after date. 30 years later, nothing has changed. It's exactly the same. Even now, adjournments keep on happening, and there are allegations of adjournments being purchased also in the lower judiciary. So what will happen is, say I'm a lawyer, I'm an advocate fighting a case, and I know I'm about to win the case. The judge is about to deliver the judgment. I'll approach him and say, sir, my lord, can I approach the bench? I'll go to him and say, sir, I have heard that you are, this party, you'll give a judgment today, and my fees collection is pending. And if he goes away, it'll be difficult for me to catch him and get my fees. Give next date for judgments. Don't give judgment today. Let me take my fees from him. And just when I'm leaving, I'll say, sir, my lord, I have heard that you wanted a 4 BHK in that society. Let me know. I know nice people. That's it. This is what you do. So adjournments are purchased. There are allegations of corruption, especially in lower judiciary. This is there. Then in our country, there are, lot of procedural complexities. Too many laws which are very, very old. Old laws, obsolete laws. Look at, old, obsolete, archaic laws. Very old laws. Look at the IPC only, Indian Penal Code, 1860. Every few weeks, few months, some section is challenged in court for being unconstitutional. The Code of Civil Procedure is of 1908. Indian Police Act, IPA, 1861. Indian Evidence Act is of 1872. You can Google for these full forms, okay? So don't worry, simply type that and Google for the full forms. So Indian Evidence Act, very old law, and there are a lot of loopholes in the law which are misused largely by the lawyers. And intellectual lawyer, somebody who is well informed, is up to date, has trained under important people, has a lot of knowledge in the field of law, knows how to exploit these loopholes, right? That's there. So this is again a very serious cause of concern. In fact, Law Commission in the 69th report 1977 185th report 2003. It has constantly said, please revamp all these laws, make new laws now. These are British made laws. What are you waiting for? 200 years, then we'll make a law. Apart from this, one more issue is that people in our country love to file cases. We call that frivolous litigations, useless kind of litigations, just to gain popularity. Simply to gain popularity, they'll file some kind of case. That's it. And again, frivolous, useless, just for fun. That's there. A classic example is something called PIL. We'll discuss what is PIL shortly. I mean, today only, hopefully. That's there. Then one more very big issue is the infrastructure quality. Very poor infrastructure at the lower judiciary. Of course, at the higher judiciary, see, the courts you see in the movies, they are actually high courts and Supreme Court, right? So in the lower judiciary, it's very, very pathetic. For example, I'll give you just some examples. You'll be shocked at the situation in which our subordinate judges are working. 46% court halls, no purified drinking water. So in the court premises, you will not get purified drinking water also. Forget this. In 26% of the courts, lower courts, there is no ladies' washroom. In 16% of these lower courts, there is no men's washroom. So you have to come there, work from 10 to 4, can't drink water too much because you'll have to use the washroom. No washroom only. How will you survive there? You are wanting to go back home as soon as possible. I mean, go and look at the courts that are there in some tier 2, tier 3 towns. One dingy room, one judge sitting there, only one bulb on his head, one fan towards him, 2 or 3 broken benches. This is what is the situation. And there are almost 68% cases where there is no separate record room to keep the records. So when you submit any kind of record to the judge, it is kept there only on one side. Any random person can come walking, say, my lord, look there, takes the file, runs away. That's it. File gone, lost. This is a situation. Then computers, of course. One more sad story. 63% cases, no computer on judge's table. In fact, in almost half the courts, lower courts, there is no library also. Now you say, why library is required? See, legal books are very costly, okay? And as a judge, you have to refer to various books and all. You cannot be expected to buy all these books. You are a government employee, especially lower level, your salary is very limited, right? So you don't expect them to buy books worth thousands and thousands of rupees every day. So we need a library for reference and all. It's not there. So this is with respect to the poor infrastructure, which actually impacts the quality of justice being delivered. Imagine you go to your Sachivalaya, the secretariat, and you have poor facilities, lack of sanitation. You will not tolerate for a single day as an IAS officer. You want your bungalow, your office to be neat and clean, perfect. But look at how they are functioning. And then we expect them to, uh, provide justice quickly. Now, center has said, for this at least, the steps taken, center has devolved around 5,307 crore rupees to states. States are expected to put in roughly around 3,700 crore rupees to improve the infrastructure. And we also have now this Nyay Vikas. Nyay Vikas is an online system of geo-tagging. So in any, let's say, court, if a washroom is built, we have to geo-tag it that a washroom has been built. So this is there. So these are some reasons for the pendency of cases in the country. I hope now you understand why we have so many pending cases. But then the whole point is, how do we solve this problem? After all, the problem needs to be solved. Tell me, please tell me, how to solve this problem. Don't be the Hindu column writer. Tell me how to solve problems. Use of AI. A lot of you are writing use of AI for what? Giving judgments. Chat GPT to give judgments. That would be too much. Not possible. Okay. So I've read all of your points. Let's summarize those points. I think most of your points would be covered here. Corrective measures. What steps can be taken? Number one would of course be enhance the judge to population ratio. This should be how much? At least 50 per million people. For every million people, there should be at least 50 judges. Now, for that, we can't kill people, right? To bring down the population, we have to increase the sanction strength. This means increase the sanctioned strength. Number two, of course, filling up the vacancies that is there. Then one more thing, setting up fast track courts to deal with older cases. So let's say, now what is a fast track court? Fast track court is a regular court only. Please hear me out first. Fast track court is a regular court, nothing special there. It is just that in that court now, only certain matters can be filed. So we can have a fast track court where only those cases which are 20 years older will be filed. So that judge will now take up only those cases which are older than 20 years, because normally in a court you can file all kind of cases, but we'll allocate some judges this task, that for you now the only task is you take up the cases which are 30 years old, 20 years old, 10 years old. Okay. Then now we have some fast track courts. Presently, 489 in almost 19 states or UTs. Then, of course, revamp old laws. Old laws need to be revamped. Then, virtual hearings. So encourage that wherever possible. Wherever possible, encourage the virtual hearings. That's also there. Then some other things like training the police, capacity building of police personnel. So police personnel, they should be trained, because see, the sad part is uh, most of the high level training is received by people like you, IPS officer, etc. But at the lower level, the police constable, ASI, etc., they hardly get trained. And these, look at the constable also. You are expecting the constable to solve all the issues. Like, it is the same constable who reports to the crime scene, who is the first person who arrives at the crime scene. It is the same constable who's also given the task to control the rioting in case of some riots happen. The same constable who also takes care of, law and order situation. Same constable also takes care of some cyber crimes. Same constable also takes care of any political rally. Same constable also takes fruit, vegetables to your house as an SP, DIG, IG. You extract work from them. So, and don't expect them to then be amazing at their task. That's it. So, training is important. Then other things like improve infrastructure, right? Also, a very important point. See, we cannot increase the number of sittings of Supreme Court. That would be a bit of a problem. I'll tell you why. See, Supreme Court judges don't go home and enjoy, party. No, they're not partying and all. What they are doing basically is they are studying only. In their leaves, they don't go to Goa and Amsterdam and they are celebrating. They are studying back home, because they will take, or they will be a part of, say, 20 judgments, 30, 40 lawyers giving various kinds of arguments. I can't trust all of them. I have to read personally. Then I have to write my judgment. It takes time. But what we can do is, why do they need summer vacation? All the judges going all at once makes no sense. See, British people did not or had no idea how to tolerate the Indian heat. These are all Indian people. And the courts are fully AC, their cars are fully AC, their homes are fully AC. Why this summer vacation? You want leaves, we'll give you leaves. But not all people at the same time. Okay? So, we will spread, or we call it stagger, leaves of judges throughout the year. Meaning, before the beginning of every year, ask a judge, how many leaves do you want? And the judge says, or when do you want those leaves? Some judges can take leave in January, some in February, some in March. In this manner, the court functions throughout the year. Otherwise, every year in the month of May, June, July, the court hardly functions. It's closed for almost 45 days. And then all the cases pile up. So spreading the leaves across the entire year. And of course, we also need to popularize alternate dispute resolution ADR mechanisms. Meaning what? Alternative way to resolve disputes like Lok Adalats, like Gram Nyayalay, etc. Okay. Then we would also need to slightly revamp the collegium. Or let's not write a point like this here. Let us add this point in vacancies only. Reform in the appointment process. So these are some of the steps that can be taken to reduce the pendency of cases. Okay, that's it. Now, coming to some examples of Lok Adalats, what are they, and also what is Gram Nyayalay. Okay. Unnecessary PILs. We have provisions of penalties, but what can we do? People still keep on filing PILs. Magesh, I am telling you, understand, wait, Lok Adalat will discuss that. Privatization of judiciary. Time, see, for all those who are suggesting time limit for a court case, no, that will not be justified. Because quick justice also means no justice at all, right? So fast track justice is also fast track injustice. You cannot time bound a judge to deliver justice in a very limited time period. That would put pressure. So 10 minutes remain. Okay, 9, 8, he is criminal, punish him. That's what will happen eventually if we time the judges like this. So that may not be possible. Okay. No, again, working days will not be increased. That is not possible. Okay. But don't worry about ADR. I'll explain ADR, alternate dispute resolution mechanisms. Lok Adalats, that's the next topic. Please ignore it. Vijay, conduct survey in courts. What's the meaning? How will that help? What kind of survey do you want? Population control. That is not in our hands, right? Yes, Yashika, all these steps will only be taken or done by the government and the what? Courts. This is just a polity class where we are discussing what can be a possible solution. Now, don't ask me why is the government not doing it. I am not the government. I have no control also. I don't have the contact information also of the Chief Justice of India to WhatsApp him this information, right? Survey, what kind of survey? I am giving you facts on older cases. Facts are available. So what? How to solve that? Fast track courts. File RTI for what? What do you want to know? RTI. So mean virtual hearing means online hearing. Virtual, online. Shalu, visual hearing? Did I write visual hearing? Virtual hearing. Sometime it may happen that a lawyer is not available in the city and he wants adjournment. The lawyer can be anywhere and can take the case in front of the judge. So it will also save the time for the lawyer to travel to multiple places. A person, a witness, not available. He can be asked to be a witness online also. So are you asking me how online things help while taking an online class? Remove 20 years ago cases. How? We have to actually solve that problem. Blockchain technology. Read, tell me how to incorporate blockchain in solving a case. Judgments have to come through a judge who has vast knowledge and experience in not just the field of law, but also human emotions. Okay. Shalu, why? Please take my question. Okay, Shalu, I take most of your questions, I believe. Why cases of rich are heard very quickly, sir? Please tell. Madam, this is the reality of life. Why only you are able to come to Byju's and get the advantage of amazing teachers like me? I mean, like other people. Why? Because you have money. Similarly, if somebody has more money than you, they are able to hire better lawyers. Okay. So enough of your emotional arguments, lie detector test. Anyway, minimum number of cases to be resolved in a month. How? The point is that we have to increase judges and all. It will be challenging for these judges to solve all such cases. Otherwise, quick justice means also quick injustice. Anyway, so these are some corrective measures that can be taken. Don't worry. How can we change old laws? By making new laws. The parliament can make new laws and can change the old laws. Judges are also too old in age. Yesterday somebody was saying that they should not be retirement age. Judges gain experience. Now today you are saying that too old people. When you get too old, you also get more experience. That's also there. With age comes experience. Anyway, okay, let's move on to the alternate dispute resolution. What can be done as an alternative? These are things to improve the court system. Can we, or is it like always an option only to go to court? Why don't we create an opportunity, right? Why don't we create an opportunity to help people not go to courts only, solving their disputes without going to court? Lok Adalat, a very interesting concept is Lok Adalats. Now, how does the Lok Adalat function? I'll explain that first with some real kind of example. See, this is a real photograph of a Lok Adalat. Let me explain this first. So, think of you as an individual. Now, when it comes to you, let's say you have taken a bank loan. You have taken a bank loan of let's say 80,000 rupees for whatever reason. On this bank loan, interest is charged, yes or no? Slowly and steadily, the bank loan becomes 1 lakh rupees. Now you have stopped paying the interest. Don't pay the EMI for 1 month. The loan becomes a special mention account, SMA1. Don't pay the EMI for second year, it becomes SMA2. Don't pay for third month, it becomes an NPA, non-performing asset. Bank has realized that they have made a big mistake, right? Big mistake. Now, eventually bank will remove your loan from the loan books because they know there's no profit here. But this does not mean that the bank cannot collect money from you. Now, bank thinks how to collect money from this fellow. How? Bank will send you a letter saying, Mr. or Miss ABC, whatever, we gave you a loan and shamelessly you never ever returned the money. But nevertheless, we are offering you an opportunity. So a letter comes from the bank. Here they may say, we are giving you a waiver, a haircut of say 30% discount of 30%. Meaning, whatever is a pending loan, don't pay all 100%. Just pay 70,000 rupees. We are satisfied. Are you in agreement with this? If you are in agreement, come on that day, some Saturday, in the local court. Please come at 11 a.m. with this letter and we'll solve the problem. So, if you are ready and willing, like in this case, you will go. So, these people ideally are the ones who have taken some loan. In the local court on Saturday, you will have this person. This person is basically the chairman of the Lok Adalat. The chairman of Lok Adalat is normally a retired district court judge. Look at his face only, always angry, retired district court judge. There are some other people also, two other people, this person and this lady. These two people are basically experts in that particular area or domain. Maybe some retired bankers, etc. are there, or maybe some bankers or experts in the field of banking are there. There is some person who is moderating this, calling names of all the people. There are people waiting. All these people are waiting. Bank also sends their lawyer. This person is bank's lawyer. Look at his face only. He feels completely, exasperated with life. So that's there. So this is a situation. Other people waiting for their case, typically going behind, seeing when their name is there in the list. Typical behavior, no queue is maintained. So this is how a Lok Adalat actually functions. Name is called. If you are willing, you will sign. Bank's lawyer signs on the behalf of bank. Case resolved. You agree to pay 70,000 rupees. Whatever the condition, the bank says immediately, the bank says in 6 months, depending on condition. So you also are a winner there. You took 80,000, 1 lakh is pending, you have to pay only 75,000 or 70,000. Bank also got something. Something is better than nothing. Half a loaf is better than none. So it's a win-win situation for both the people. This is what is a Lok Adalat. So Lok Adalat, the idea is amicable. What is amicable? Peaceful, cooperative, settlement through compromise. Okay? No problems at all here. We'll simply settle the dispute, settle the problem with ease. There is an element of flexibility. There is an element of affordability. Look at these poor people. They did not need to hire any lawyer. And bank has hired a lawyer because it eases the task of the bank. Some bank officer also come and will be there, but normally bank's lawyer is there. It also is very important to understand that there is speed in this. Same day, problem solved, right? Then it is amicable, peaceful, no fighting in the court going on. And there is an element of finality. The matter is over, it's final, done and dusted, case closed. That is why we say that the Lok Adalats deliver informal, cheap and quick justice. The Legal Services Authorities Act, the same act under which we had NALSA, was amended in the year 2002 to provide for permanent Lok Adalat. Now, what type of cases does the Lok Adalat deal with? Public utility cases. I gave the example of bank for easy understanding. Examples could be bank loans, water bills, electricity bills, accident compensation. In fact, not just this, even family matters. There are Lok Adalats called Parivarik Lok Adalat, where family disputes can also be resolved. Clear on this? So normally they are referred to as Mahila Parivarik Lok Adalat. So you can go there, get your dispute resolved. If you want a divorce and all these things. Okay, but basic issues. If you are beating your spouse, then sorry, that would be a criminal offense. Generic issues like the spouse does not wish good morning, good evening every day, no hugs are there in life, no romance is there in life, you are getting bored, etc. Do not take the spouse out for dinner. All these issues. Please don't include domestic violence here. Okay? So, basic kind of issues. Yes, TV remote fighting, all these things, right? Spouse, Vijay, spouse, husband or wife is called spouse. You'll get to know slowly in future. These things exist in life, right? Loved ones are there, all these things. Anyway, the crowd is slightly too diverse. Too young people are there, so I have to refrain from jokes which are based on romance. They have no experience of all this, I believe. Difficult times. Anyway, so this is Lok Adalat. Now, this permanent Lok Adalat comprises of 3 people. One, the chairman. And the chairman will always be some retired or a sitting district judge. Though even high court judges are there who can become the chairman, and they are in case of high courts and all. But normally at the lower level, it is just some retired district court judge. Now, again, when it comes to district judge, it could be a sitting judge also. But the point is that sitting judges are too busy in their life. They just get Saturday, Sunday. They don't want to go to the court. So mostly retired judges will come. Apart from it, every permanent Lok Adalat also comprises of two members who have adequate experience in public utility services. Like these 2 people. These 2 people, they are not this person here and this lady here. These 2 people are not district judges or something. They are just people who are maybe experts in the area of banking, etc. in this case. So, experts. Now, some important points that you have to understand. Point number 1. What kind of cases can you approach the Lok Adalats for? See, firstly, Lok Adalat is not some very unique or recent concept. If you go back to the origin, right here, the very first Lok Adalat in the country was conducted in Junagadh, Gujarat. So, proud moment for people from Gujarat. 14th of March 1982. So it's a very old kind of concept, right? So anyone from Gujarat here? I'm not sure, because normally people from Gujarat will feel why to study and all business. That's where the money is. Okay, we have few people who have no interest in business. They only have interest in harassing the businessman in future. Great. So this is there. Now, important points. As I said, number one, what kind of cases can be filed in the Lok Adalat? You can always approach the Lok Adalat for any civil kind of case. No problem here. Civil cases, you can go to Lok Adalat. But compoundable criminal cases, there are certain cases which are criminal cases. For that also you can go to Lok Adalat. Now, what is a compoundable criminal case? Compoundable means petty offense, small offenses, where out of court settlement is possible, is allowed. Are we clear? For example, in your school or college days especially, you know very well, these groups are formed and these groups have some gang leader. They think they are gang leaders. They'll fight each other to impress some random person who has no idea also that you are fighting for him or her, whatever the case is. Then the police comes, slaps both the parties. They don't file a case. They say, come on, shake hands, get lost, case closed. Or you are, say, traveling outside at night, fighting with your friends on the road, birthday bumps on the road only. Police will not file a case. Maybe pickpocketing, right? Stole somebody's bike, snatching off the chain. The police can say, return the chain, say sorry, sit up 20 times. That's it. End of case. It does not include things like killing somebody, assault, attempt to murder. No. Those are serious offenses. Bank dacoity, no. Somebody's pickpocketing you're doing, that's a petty offense. If you're robbing a bank, that's a serious offense. Clear? So this is there. Now, Lok Adalats are available at all times. Meaning, you, let's say I am the bank here. Now, somebody has not returned the money. I have two options. I can go to court. I can also try my hand at Lok Adalat. Anything is okay. I can go to the court, and while my case is pending in the court, somebody comes and tells me that, why don't you file a case in Lok Adalat? I'll try that. No problem. Or before going to court also, I can firstly try in Lok Adalat. So, pre and post litigative stage, meaning before or after filing case in court. So you can always approach the courts, Lok Adalats, whether your case litigative stage, meaning what? Where does litigation take place? Litigation, courts. So litigative stage refers to the court stage. Are you clear? So at any point of time, you are free to approach the Lok Adalats. Clear? Now, one very, very important point to understand. The award which is given by Lok Adalat, whatever you have signed here, and the judge says it is binding. Clear? Whatever award is given by the Lok Adalat is binding. It cannot be challenged in any court, whether High Court or don't ask me, sir, can it not be challenged in Supreme Court also? No, it cannot. And I will tell you the reason why. Lok Adalat is not some kind of adversarial fight between A and B. It is a compromise. The bank said, are you willing to accept my offer? You said yes. That's it. You say no, case closed. No case in Lok Adalat. So you cannot challenge that particular point. For example, a better example. Let's say once you clear the examination, a lot of people will come to you saying, I love you so much, I always loved you, etc. They'll express their love for you. You'll get cards, letters, messages everywhere. Now the point here is, when somebody comes to you and says that they love you, you cannot ask them, no, why have you come? Why your friend has not come? Why? Your only response can be yes or no. Please don't ask this kind of question that why your friend has not come. Sorry. Same logic here. You can either accept the bank's offer or reject the bank's offer. You cannot question the bank's offer. Why am I not getting 30% off? Why not 40% off? No. Why you accept the offer, good for you. Otherwise, sorry, no problem. That is why the award is binding. It cannot be challenged in any court. Again, Pawan, same kind of problem. Lok Adalat will only give a judgment if you go to Lok Adalat. Don't go there. That's what I'm saying. If you do not like the Lok Adalats, see, why will this person go to the Lok Adalat? Why? Because the bank sent them this letter. If I don't like the offer of the bank, why will I go to Lok Adalat? I'll say, no, I don't want to go to Lok Adalat. That's it. The bank can go and file a case in court. So I will only go to Lok Adalat when I like the offer. So how can I challenge the offer? I don't think there's a better example that exists beyond this. That when somebody approaches you, you cannot question them why your friend has not come. I was waiting for your friend, not you. You get lost. Clear? And you can approach the Lok Adalat for any amount which is up to 1 crore rupees. This is as per the NALSA website. So in your books and all, if it is mentioned 10 lakh rupees, that's a wrong figure. Up to 1 crore rupees of dispute, you can go to Lok Adalats. Are we clear on this? That is all as far as Lok Adalats are concerned. And yes, as I said here, you can always go to the court if you don't like the offer given by the other party to you. This is not bound. You are not bound to accept the offer. But once you go there and accept the offer, that is final. You cannot question that offer. Understand the logic. Okay. Who pays fees to Lok Adalat officer members? This is very petty kind of concern here. These people are paid by the government. Who else will pay? Who do you think is going to pay? What do you think? Government. Government pays them money. Don't worry about who is getting money. Where is he getting money from? What kind of phone he has? That is, again, irrelevant information. But for your understanding, government pays money. Where else will the money come from? Are judges doing some kind of service to gain money or what? Of course not. It is always the government spending money. Are we clear on this? See, 1 crore meaning if there is any, let's say this bank dispute was of how much amount? 70,000 rupees or 1 lakh rupees. You can go to Lok Adalat. If the dispute is 10 lakh rupees, you can still go to Lok Adalat. If the dispute is 90 lakh rupees, you can still go to Lok Adalat. But if the dispute crosses 1 crore rupees, then you cannot go to Lok Adalat. You have to go to the regular courts that you have, not the Lok Adalat. The limit is 1 crores. Okay. So this is all about the Lok Adalats in as simplistic way as possible, as humanly possible. Now there have been some amazing things. Lok Adalats don't take place every day. They take place on certain occasions only. And just to give you an example of some number of cases solved by Lok Adalats. Example. In 2021, you will be surprised. The Lok Adalat disposed of 1.27 crore cases. Disposed, meaning solved or finished. In 2022, 4.19 crore cases were solved. You can understand the value of Lok Adalats now. If we did not have Lok Adalats, these matters would have gone to some lower court. And the pendency figure that we are looking at 5 crores would have been 10 crores. So it's all thanks to Lok Adalats that this matter has been resolved. All these cases have been solved without even going to the courts. Are we clear? These are the advantages of the Lok Adalats as an alternative to going to court. Okay. What is Nalsa? Somebody says, what is Balsa? And I think all three of you did take the class yesterday. Look at the yesterday's PPT. National Legal Service Authority. Nalsa, Salsa, Dalsa. At least don't write Balsa. Write Nalsa at least. Okay. No problem. So this is all as far as, yes, lesson 21 because of COVID. That is there. Yes, National Legal Service Authority, NALSA. We discussed this yesterday. Okay. That's all as far as the Lok Adalats are concerned. We are done with our discussion on Lok Adalats. I'll just summarize these 3 points for our innocent people here. Lok Adalats, you can approach Lok Adalat for cases which are civil or even compoundable, petty criminal cases, not the serious criminal cases. Number 2, you can approach Lok Adalats at any point of time, before filing a court case, pre-litigative stage, or after filing a court case also. Lok Adalat is an alternative. You are always free to approach the court, always. It is just that you know that there will be a lot of delay in the court system, so you are trying to find an alternative, right? And whatever decision has been given, whatever compromise has been arrived, that compromise is final. It will not be challenged in any court. Please don't ask me and mail me after 30 days that, sir, in Supreme Court possible? No, it is not possible. Understand the logic of your question also. How can you challenge a compromise? You have accepted the compromise. If you don't like the compromise, don't accept it. You cannot question the compromise, right? And lastly, the limit to which we can approach the Lok Adalats is only 1 crore. If there is any dispute involving an amount more than 1 crore, you have to go to regular courts. That's it. Done. Please solve this question. Came in the year 2010. XY, if one is forced to compromise, how can somebody force you to compromise? If somebody comes you and says, I love you, how can they force you into loving them back? I don't think that's possible. Okay. How is it possible? Ji Yashika, I would love to know how is it possible. TH Candy. See, Candy, when it comes to adjournments, after this question. How did we get such low correct answers? Lok Adalats have jurisdiction to settle the matters at a pre-litigative stage only and not those matters pending before a court. I just said before or after filing case in court. Just mention a point here. One is wrong. Okay. Lok Adalats can deal with matters which are civil and not criminal. They can also deal with criminal matters, compoundable criminal matters. 2 is wrong. Every Lok Adalat consists of either serving or retired judicial officer only and not any other person. Look at this photograph. 1 judicial officer and 2 non-judicial people. Photographic evidence is there. Here also 2 members having adequate experience in public utility service. So 3 is also wrong. D. None of the statements are correct. Okay. So that is all as far as our Lok Adalats are concerned. Yes, Candy. See, when it comes to adjournments, there can be 2 ways to curtail it. 1, to keep a track on the police's behavior especially. That we will only give adjournments based on concrete issues. not some vague kind of excuse. And number two, also curtailing the lawyers from seeking adjournments. That has to come through internal code of ethics for lawyers. We can't externally control it or monitor it. It's very difficult. Anand Padmanabhan, Lok Adalats are held normally, it would the government announces way beforehand. The permanent ones are held 4 times a year, and the other Lok Adalats are held regularly, depending on whichever no, domain that you are in. Let's say for a bank would at regular intervals hold a Lok Adalat, where all the loan defaulters are told that if you want, you can come and get your problem resolved. Okay. Read, I don't understand how to use blockchain to store evidence and all. I mean, how can you store physical evidence through blockchain? That's the point. Tanu, but sir, B option, what is the problem with B option? Because everybody is appointed by the courts only, right? At the high court level, they will make recommendations for the appointment. Yogita, A option. What A option? A option is wrong. Okay, that's all. Let's take a break. After the break, we'll take up for discussion one more unique way to solve the problem of pendency. That would be Gram Nyayalay. Okay, so Gram Nyayalay Act 2008. But that after the break, take a break, be back at 6:52. Break, please. Welcome back, guys. Sorry for the delay. Oh, where are you? Are you here? Yes, yes, yes. Have patience. Okay, Vikas. Comments need to be moderated, right? Okay, so now Gram Nyayalaya Act 2008. So what is this Gram Nyayalaya Act? So Gram Nyayalaya Act created the provision of Gram Nyayalaya. Gram is village, Nyayalaya is court. For those who come from the southern part of the country, Nyayalaya, a Hindi word, refers to court. Gram is village. So, village court. Now, not exactly a court in the village, but somewhat like that. So, what is the purpose of this Gram Nyayalaya Act? A law was passed wherein the idea was that if you cannot go to courts, the courts will come to you. Are we clear? If you cannot go to courts, the courts can come to you. And so providing access to justice to citizens at their doorstep, not exactly in your house only. Judge will not come to your house and knock and say, come on, any dispute resolution, that is not there. But somewhat like this. And to also ensure that justice is not denied due to social, economic, or any other disability. So what is this Lok Adalat? Gram Nyayalaya? Gram Nyayalaya is to be established at intermediate panchayat level, block level. Now, there is also a possibility that we can have a Gram Nyayalaya for a group of Gram Panchayats or for group of Gram Panchayats. This is also possible. Now, in our country, we have Gram Nyayalayas or Gram Nyayalaya Act. This act is applicable to the entire country. Exception is all these northeastern states largely. For example, Arunachal. For example, Nagaland, Sikkim, and also Schedule 6 areas. What are Schedule 6 areas? Details later on. In these areas, we do not have the concept of Gram Nyayalaya. For other areas, we do have the concept of Gram Nyayalaya. But in our country, we do not have Gram Nyayalayas everywhere. Currently, operational in only 10 states. And the number of operational Gram Nyayalayas in total are 370 only across the country. Most of them are, I think, in MP, then UP, then Rajasthan. Maximum in MP, then UP, then Rajasthan. Anyway, now this Law Gram Nyayalaya Act came into force in 2009 on the birthday of Mahatma Gandhi. So came into force on the 2nd of October 2009, as we know very well. So every Gram Nyayalaya will have one judge. that person is the presiding officer who is called Nyayadhikari. Basically, Nyayadhikari is a judicial magistrate of first class. First class judicial magistrate. That's it. Okay. They will be appointed by the state government, but in consultation with the High Court. And they get the same salary as the what? The JM first class. So this is the Gram Nyayalay Act. Clear on this? Everyone, so far? Pritam, in 2008, what happened? What happened? I don't know. No idea. So now comes the point. So basically what is going to happen is, as we said, the courts do not go, if you can't go to court, the court comes to you. So they hold mobile courts. Does not mean that they will take a van, and the judge sits in the van and goes here and there, and then asks people, come on, justice, justice, take justice from me, right? If you remember the Nana Patekar scene from that movie. So that is not going to happen. What will happen is, in one intermediate panchayat, an announcement is made that on the 24th of May, for the next 15 days or next 1 month, a Gram Nyayalay is going to be organized that day, right? All those people who have their problems, their disputes, issues, etc., please approach your Gram Panchayat and let them know of the dispute. Gram Panchayat can then contact and raise all those concerns. If you have a problem, approach the Gram Panchayat. They will file or put the notice or inform the Gram Nyayalay. Now the Gram Nyayalay gets the list of all the disputes that are there. The judge comes from that day. You go to the Gram Nyayalay, stand there. The judge asks you a question, you tell your concern, no need of a lawyer, nothing is required. Other party is called, other party responds. Both the sides are heard. Principles of natural justice are followed. Justice delivered within 6 months. Case disposed of in 6 months. This is how the Gram Nyayalay functions. Holding mobile courts, periodically visit villages and conduct trials and proceedings. Clear? They take up both criminal and civil cases. Now, apart from this, as I said, the Gram Nyayalays don't really need some lawyer. They simply GN. Don't ask what is GN. No, I'm sure you will ask. So let me write it here. Gram Nyayalay, GN. Before somebody could ask. So in case of no lawyer, etc. required, the whole point is they follow principles of natural justice. And let me remind you, yesterday we had seen under SLP, principles of natural justice, 3 principles of natural justice. Anyway, apart from this, Gram Nyayalay will also try to provide for peaceful settlement of dispute. Okay. For that, it can approach the district magistrate and can ask the DM that why don't we appoint some local people, local village influential people as conciliator. For example, let us say you work in somebody's farm field and the person had to pay you some money and the person did not pay you money or did not pay you the complete amount. So, we have these laws like the Payment of Wages Act 1936, Minimum Wages Act 1948, or maybe somebody's cattle has, come into your field and has destroyed your crops. Now you want some kind of money, right? So there is a law called Cattle Trespass Act 1871. For all these petty issues, you can approach the Gram Nyayalay. Now, the Gram Nyayalay gets a list of all these issues. If there are some very basic issues, like say somebody is not paying the minimum wages, the Gram Nyalaya, the judge can also say, come on, local Gram Panchayat Sarpanch, why don't you solve the problem? Why do you need me to give some kind of punishment and all? Solve the problem. So sometimes we also go for a settlement for which conciliators are appointed. Some local influential people, social activists, etc. can also be appointed as conciliators, mediator, intermediary to solve the problem. Otherwise, we already have the Gram Nyalaya, Nyayadhikari, who will give the verdict. Limit. Gram Nyalaya cannot give you a fine or impose a fine of more than 20,000 rupees. That's the max limit of fine. And no punishment can be given more than 2 years. Arun, sir, not oscillators, yaar. It's not oscillator. Conciliator. Mediator. When you have to approach somebody to express your emotions, you ask a friend, why don't you go on my behalf and tell the person how much I love you? That friend is a mediator. Okay? When two people fight, you call somebody that please resolve the fight. That person is called a mediator or a conciliator, not oscillator. So, criminal cases, punishments cannot exceed 2 years. One more thing. Here, filing case is not free. There is a fees. If you want to file a case in the Gram Nyayalaya, there is a fees of 100 rupees. Secondly, appeal is allowed because it is a proper judgment. There is no compromise here. But appeal only when there is a jail sentence or fine more than 1 rupees 1,000. Okay. So if there is a fine of rupees 1,000 or more, then you can appeal, or not more, more than. Fine of more than 1,000, then you can appeal. Otherwise, you have to pay the fine. There is no alternative. Chahat, no fees in Lok Adalat. Lok Adalat has no fees. Gram Nyayalaya is actually giving judgments. Proper judgments are being given. You know, jail sentence is there. Here, it is not some compromise. It is a proper judgment. That is why here court fees is there, 100 rupees only. Affordable, not a big amount. And just to tell you the importance of this, roughly they receive 16 to 17,000 complaints per month on an average in the Gram Nyayalayas. And they receive 1.6 to 1.7 lakh criminal complaints per month. Are we clear? So this is with respect to the Gram Nyayalaya. No, award is not final here. You can appeal against this judgment. Okay? Appeal is allowed. Yes, you can approach the district court, go to High Court, Supreme Court, etc. Anand Padmanabhan, innocent question. Sir, where is it held? Is it held at the intermediate panchayat level? Did not understand. Block panchayat. How do you know about the dates and functioning? Nobody will give you a personal phone message. You have to contact the intermediate panchayat. So go to the Gram Panchayat member, talk to them if you have a problem, and then they will tell you when the next Gram Nyayalaya meeting or when the next Gram Nyayadhikari will come to that block panchayat. So all these things are available in the public domain. It is just that only interested parties look for this information. It's all available. Shalu, appeal point. What appeal point? If you are given any jail sentence by Gram Nyayalaya, you can appeal against the judgment. If you are given any fine of more than 1,000 rupees, you can appeal against the judgment. That's it. Which type of cases? Civil cases, criminal cases. Any criminal case where the punishment is less than 2 years. Small criminal cases. That is where you have the Gram Nyayalaya. Where appeal? Where will you appeal after Gram Nyayalaya? You'll go to the lower courts, subordinate court, then go to High Court, then go to Supreme Court. Shruti, what is the difference between Lok Adalat and Gram? They are two different things completely. Lok Adalat does not give a judgment per se. They settle a compromise. They arrive at a compromise. When two parties agree to come to a compromise, Lok Adalat only certifies and approves the compromise. Are we clear? Gram Nyayalaya is a proper court where judgments are given. One party is wrong, the other is right. So it's completely different. It's like a court only. Lok Adalat is not actually a court. When two parties have agreed on a compromise, they go to Lok Adalat and get the compromise resolved properly. Right? Certified, approved resolution. That's there. Okay. Ravi, sometimes an intermediate panchayat can have 10 gram panchayats. At that, in this place, we can also have a gram nyayalaya for only 4 of the gram panchayats, not all the gram panchayats in the entire intermediate panchayat. Clear? Okay. Shruti, that is the Panchayat Bhavan. That is not Lok Adalat. The Zilla Parishad office is what you are referring to. XY, no. How will one party go and file a case in Lok Adalat? It makes no sense. If I don't accept your compromise, I won't go to Lok Adalat. Then what will you do standing there alone? Right? We are done with our Lok Adalat. And now solve this question. Okay, 72% got this correct. As per the Act, Gram Nyayalayas can hear only civil cases is wrong. They can hear both civil and criminal cases. One is wrong. The Act allows local social activists to act as mediators, reconciliators, whatnot. B is correct. Okay. Now, one more thing. Leaderboard. After every few questions, leaderboard. Okay. Oh, that is why Nitesh was asking for leaderboard. Amardeep, Sneha, Nitesh, toppers here. Others at 60. Till Avni, Mayank, Sairaj, and Bhavna, Shalu, Mayavanshi, Sulekha, Utsav, Jagdish, Gopal, Shobhit, Miriala, Venkata, Kendi, Gangte. Okay. Snehlata, Gram Panchayat set up under law not mentioned in constitution. Do you need me to answer this question? You tell me, Snehlata. Please. Are Gram Nyayalayas constitutional bodies? Yes or no? You are answering your own question. Then why asking me a question? See, of course not. They are made through a law. Okay, statutory. Anyway, yes, as far as Monday is concerned, 1st of May, no classes on Monday, full enjoyment of 3 days, Saturday, Sunday, Monday. Enjoy, party, have fun, waste your time, but also study, please. Okay? Why? Why Monday is off? It's Labor Day, 1st of May. So 1st of May, Labor Day. All thanks to our communists that we celebrate a holiday on Labor Day. Yes. You can watch Ponnai Selvan 2. You can also watch some other movies, etc. But please revise. Okay, guys. Now, All India Judicial Service. Firstly, let me help you understand this. What do I mean by this? So you have the IAS, right? What we refer to as the Indian Administrative Service. You also have the IPS, Indian Police Service. You also have the Indian Forest Service. These are the currently 3 all India services in the country. What we think would be a good idea is to also have a judicial service, all India judicial service, not for High Court and Supreme Court, please, for district judges. For district judges. This is mentioned under Article 312. This was, allowed for in 1976, and we have now, as of now, just 3 all India services. Should we have an all India judicial service? Yes or no? Sorry, don't write yes or no. Please write reasons also. If yes, why? If no, why not? Basically, UPSC will be expected to hire people for this kind of service. Shalu, please don't make these statements. This is just an idea. Okay, it is not practically applicable now. Faster delivery of justice. Femina, please explain how. More talented, regional language barrier, part of bureaucracy. Good justice, no nepotism, reduce burden, pendency will reduce, more talented people. Oh, okay. Pritam, no, UPSC and judiciary syllabus different. Hare, we'll have a judiciary syllabus. What's the big deal there? Okay. Let's look at advantages. Don't be angry. Let's look at advantages. First up, we understand very well that there is lot of vacancy in the country, right? Especially at the lower judiciary, we have vacancy, seats are less. So it can help in filling up all those vacancies in the subordinate courts, around 5,000 vacancies are there. Then we also need more judges in the country eventually. In fact, just to give you a data, National Court Management System says that in the next 20 years, the number of cases filed is going to be as high as 15 crores. We need 75,000 judges for that. 75 in the next 20 years. We have how many? 26. Of course, we need to hire more people. Pendency will come down. Number of judges will increase, of course. Then, as you guys said, fresh national talent is there, right? An all India merit system. Just like the UPSC civil services, we'll have UPSC judicial services. Okay. And eventually to also strengthen the judicial system, the overall justice system will also be strengthened, infrastructure can improve, all these things will happen, right? In fact, it can also address the issues of social inclusion, adequate seats for deprived people, right? Currently, OBCs only hold 12% of the lower judiciary posts. SC/ST combined hold around less than 20% of the judicial posts. So that's there. And what exactly are, or who are the people who are supporting it? Of course, the central government wants this. Of course. In favor. Who all are in favor? Number one, Government of India. Number two, Supreme Court. Supreme Court in 1992 had in one judgment said that we want an all India judicial service. But beyond that, most high courts, barring a high court like Tripura and Sikkim, if you leave those two high courts, no other high court supports this. Now, what are the problems with AIJS? Why can't we hire judges at district level through an examination directly? Lot of issues. Number one, it will infringe on the state's power. As of now, the states hire these people. So it will be like snatching the power. Snatching power away from states as well as high courts, because now center will decide everything. Okay. Secondly is the language barrier. Now, some of you may say, sir, language barrier for IAS, IPS also, but understand, for an IAS or an IPS officer, knowing the local language is always desirable. It is not a precondition to performance of your duties, because in most cases, you will not be interacting with public directly. Secondly, if there is any person who has some issue or concern, that can be translated to you by the local people there. That is possible. But if you are a judge presiding over a case, it is mandatory for you to know the local language, local jargons. For a judge, language proficiency is mandatory. We cannot rely on translators. It is simply not possible, because that is your task day in, day out. Every day, that is what you have to do. Hear people, witnesses, evidences. How can you simply not know the local language? Not possible. Translations will mostly be unreliable, because here a lot of nuances. As a judge, you will know a lot of these nuances of how somebody speaks, emotions hidden, all these things. That is why it is very important for you to know the local language if you are appointed as a judge somewhere. Then the social custom culture argument. Outsiders may not understand the local culture, local aspects, right? Apart from it, look at the tribal people. The tribal population has a distinct culture, social customs. Outsiders may not understand the custom, the culture, may not have the same respect for the culture, for the custom. Outsiders may not respect or even understand something as small as understand the local culture. And what about the promotional avenues for lower judiciary? Any which way, we have the lower judiciary who are hired by SPSC examination, they hardly get promoted. Let me tell you something. In very few cases are people who enter through the examination able to become High Court or judges, and forget Supreme Court judges. It's always these lawyers who directly enter the High Court and start becoming a judge. So the lower level judges are already facing this problem, lack of promotion. And one more thing, see, when it comes to the national talent argument, that national talent argument is actually valid for IAS, IPS and all. You here are the country's best talent. I'm serious about this. Why I say this is that, see, for a mere graduate with a graduation degree, not a professional degree, or maybe a professional degree from a, say, an average college, what is your best job prospect? IAS officer. That is by far the best job prospect that you have. But in the legal profession, the lawyers can earn way too much. Way too much. I am referring to 10, 15, 20 lakh rupees per day per case, 5, 6 cases per day, right? So this is actually also one problem where you'll find that nowadays you'll find that because of many law schools, lot of these law school pass outs are also entering the lower judiciary. But till a few years back, you would not find a single law school graduate entering this. They would join some corporate team and be a corporate lawyer or intellectual property lawyer, or try to join the family business of law, etc. Right? So this is there. So the talent argument also does not suit well for judiciary, because here, and plus, if I am an expert in the field of law, can I not directly become a High Court judge? Is it not an option for me? Just practice law for 10 years in High Court and I am now qualified to be a High Court judge. Why should I prepare for the examination, go through the ordeal 3-4 years, join some coaching, practice, then be a judge there, waste my time in that amazing infrastructure environment, right? And then get promoted slowly and steadily. So there is an alternative for somebody to directly become a High Court judge. So why would they choose the longer route? That's it. So AIJS may not really be a very good idea. Okay, that's it. Now, who have been against it? So you know very well. States in general, most of the states, and of course high courts. Most of the high courts are against it. Lot of states are on board also. Some states, like, I'll give an example. Chhattisgarh. Chhattisgarh said that we are okay, but not more than 15% seats. Or Bihar, Odisha, they said we are okay, but you have to have some kind of criteria. Minimum experience of 10 years, maximum age of 40 years. So all these criteria will not work. plus hiring somebody at the young age of 21, expecting him to start delivering justice. Look at your questions here. Not to demean anyone, but look at the innocence in your questions at the age of 19, 20, 21. I cannot trust my life on people who are asking such innocent questions. You are innocent people. You have not seen the difficult part of life, most of you. You don't have the experience. Nothing against you. That's actually very logical. So once you grow and mature, you also experience various aspects of life. You see, you travel, you learn more, human emotions, that understanding, it's all there. It comes slowly. You will not be able to empathize with somebody at the age of 40, at the age of 50. It will not come to you naturally. We basically say that if at 25, you are not a socialist, you don't have a heart. If at 45, you are still a socialist, you don't have brains. So basically, if you are young and you don't have emotions, you are heartless. And if you are old and you still are a sensitive and emotional person, you don't have brains. Life teaches us a lot of things. Experience matters. So what will be the way forward? Way forward. First thing, in such situations, because recently also central government has said, as of now, we are dropping this idea because of too much of controversy. So a best suggestion always in such cases is discussions. Discussions with all the stakeholders. Discuss with the lawyers. Discuss with the judges. Discuss with the bar council. Discuss with the universities. That is the law colleges. Discuss with all these bar associations, college professors, etc. Detailed discussion. Then improve in the meantime. While discussions are going on, in the meantime, why don't we focus on other things that can be achieved? Like improve the infrastructure. Okay. Rationalize the wages, meaning increase the salaries. If you want people to work, you need to also give them adequate salary. That's it. Then we should also have regular avenues for promotion. Promotion of lower judicial officers. So firstly, do this. And frankly, see, AIJS, All India Judicial Service, is not some one-stop solution. Lack of uniformity is not always a problem. Rather than think of it that other smaller issues should be dealt with, and a more important thing would be that if you want to create an AIJS, it would be a very mammoth task. It is a huge task which requires complete system reset, which is as of now very difficult. Rather focus on the other ways to solve pendencies, etc. Those would be a better way out rather than going for All India Judicial Service. Okay. Yes, Nitesh. 8th pay commission will have that when the time comes. Don't worry. So one more thing, in your ethics and governance classes, you will also understand this point that increasing the salary is not always the solution for corruption. Somebody who is corrupt, who has a tendency to be corrupt, we call these people as meat eaters. Nothing against meat eater. Corruption can be of two kinds, or a corrupt person can be of two kinds. One is a grass eater and one is a meat eater. I'll explain and you will understand. Grass eater is somebody, or grass eating corruption is somebody who does not demand for a bribe. But if you give him bribe, he cannot say no. Right? In the words of Zakir Khan, he cannot remain sakt. If you offer him bribe, he'll take it. But he won't demand it openly. That's called grass eating corruption. Meat eating corruption is a dangerous form of corruption. Here, the government official is actively corrupt and he demands money. For even coming to office, for even breathing, he wants money. So these people who study for UPSC with the target in mind that, okay, I have spent 30 rupees, corruption, 40 rupees, I have to recover all that money. So this is what is called meat eating corruption. Two different kinds of corruption. Anyway, so that's all as far as the AIJS is concerned. Now, coming to judicial activism. So what exactly is judicial activism? The best way to explain this is through a diagram. Understand a very basic concept here. Let us say we have three organs. I hope we are aware of the three organs. Legislature, executive, and judiciary. LEJ. Everybody is given the domain where they have to perform their tasks. So this is the domain of executive. Let us say the executive performs task in their domain. The government is performing tasks which are given to it, the expectations from the government. But we also find that there are some areas which they tend to ignore. Okay. Similarly, legislature's task is to make laws. They do make laws, but we are getting this feeling that there are certain areas where they sometimes don't make laws. Maybe they feel the people won't like this law, so let's not make a law like this. For example, let's say same-sex marriage. Now, same-sex marriage is a very difficult idea to comprehend for a lot of people in this country. You may be an educated group, you may understand that it's okay, it's somebody's personal life after all, right? But for most people in this country, they may not have this understanding. Think of this. You feel having a girlfriend or a boyfriend is nothing wrong, right? Getting married outside your caste or religion is nothing wrong. But for a lot of people, this is a difficult idea to comprehend. Parliament knows this. They don't want to make a law like this, even though they know that yes, somebody who is, say, a homosexual, it's just somebody's personal sexual preference. It has got nothing to do with his way of life, right? Why should the person be denied this basic dignity of living the life as he or she wants to? So the point is that since I as a parliament know very well that people in general do not accept this concept, right? People in general don't accept such things. They find this to be against nature, unnatural, whatever name they may call it. It's okay. The idea is if I make a law, I will be displeasing more people than I'll be pleasing, right? Why should I make a law? Let it be. I won't say yes, I won't say no. So because of these things, sometimes deliberately, the government, the parliament don't perform their tasks. Now, if you are not performing your task, judiciary also has a task to perform, yes or no? This is the judicial domain. They are performing their tasks. But if the judiciary feels that because of executive and the legislature's failure to perform the task, what has happened is that people's rights are getting violated, then I will have to interfere in your area and will have to perform tasks. Why? Because you are not performing the task that was expected of you. Of course, it is wrong. Judiciary has crossed its limit. The limit was this line, the sacred line, but they have crossed a line. But there's a reason for it. The reason is the failure of our democratic organs to perform their task. This concept is what is known as judicial activism. Okay. But there is one small problem. The problem can be that now judiciary starts interfering too much and it enters a zone where it is now telling the legislature and executive on how to perform a task which they are already performing. The blue line. This is where the matters go out of hand, because here I am telling you not like this, like how I tell you, my way. So I have basically crossed that limit, that Lakshman Rekha of sorts, where you are performing a task, but I say no, I will interfere. This is judicial interference, which is actually seen as an overreach. This is called judicial overreach, or can also be called judicial adventurism, right? Or can also be called judicial populism. Okay. So this is how we define the judicial activism and overreach. I'll come to examples shortly, so don't worry. Hold your horses. Hear me out what I have to say first. So a very appropriate way to define judiciary would be, activism would be, democracy's non-democratic alternative. As I said, I fully agree what I am doing is wrong. Did I say what I'm doing is right? No. I know very well what I am doing is wrong. I am crossing my limit and telling the executive how to perform tasks. But because executive has not performed their duty properly, so when the democratic institutions fail to perform their task, somebody has to tell them. Are we clear? This is the basic definition of judicial activism. Now, the question is, why does judiciary perform this behavior? Why? What's the need? The need is very simple. See, I'll simply quote what Justice P.N. Bhagwati said, because Justice P.N. Bhagwati, the concept has been pioneered by people like Justice P.N. Bhagwati, V.R. Krishna Iyer. These people have taken this concept to greater heights, especially the use of PILs. I'll come to all this shortly, don't worry. Just hear me out. So why would judiciary go for activism? So as I said, I'll just quote Justice P.N. Bhagwati. So Justice P.N. Bhagwati said in one judgment, that was in the S.P. Gupta case, that the court has to innovate new methods and new strategies to provide access to justice to large masses of people who are denied basic human rights, to whom freedom and liberty has no meaning. So it is, as a judge, my duty to innovate, to create strategies to ensure justice for all, right? And what reasons? Firstly, the asymmetry of power in the constitution. It's a very important reason. Asymmetry of power. Because we also have Article 142, which provides the judiciary with the power to ensure complete justice. And we know very well who is the strongest organ. Executive. Everything in this country is done by the executive only. So executive is very strong. Don't you think there should be a check? Secondly, indifferent approach of other organs towards people's problems. Towards people's problems. For example, why did the Supreme Court have to pass a judgment on Sabarimala? Right or wrong? Later. Because the parliament was not looking into it. Why would the Supreme Court have to pass a judgment on, say, transgenders? Why would Supreme Court have to pass a judgment on any such matter? If the parliament made a law and the government implemented laws properly, we would not need the Supreme Court to pass any law, right? Any judgment. So the indifferent approach, the neglect, is what forces people to approach the courts, and then the courts interfere. Of course, increasing awareness amongst masses. People have now started knowing about their rights. What is right, what is wrong, their fundamental, their constitutional, their statutory rights. Globalization, it has also impacted this. We see other countries where rights are being upheld of people of various kinds. Then active media, which brings to light or exposing government shortcomings, right? And of course, advent of PI. Guys, before I explain, there is no point, I'll explain everything in detail. So please hold your horses. When you keep on asking questions, you waste your time and then you ask to repeat later on. Trust me, I'll give you more examples than you can remember in your entire lifetime. So please, just control your emotions. Hear what I have to say first. That's why I say, don't act like a customer. Be a student that you are. So, exposing government shortcomings is what is a role of active media. And when we see government shortcomings in certain areas, people do approach the courts and the courts do interfere. And then advent of PIL. So what is this concept of PIL? As I said, Justice P.N. Bhagwati, Justice Krishna Iyer, they are known as the pioneers of sorts, founding fathers of PIL. So what basically is PIL? Public interest litigation. This is what is called PIL. Now, what is the idea of PIL? Or see, forget PIL first. Let's understand who can approach the court. Let us say somebody has robbed your house, somebody assaulted you, you can approach the court. Somebody kills you, your family members can approach the court. Fair enough, fully understandable. The point is, there is always a concept called locus standi. Okay. This concept of locus standi refers to only those people are allowed to move to the court who are impacted directly by the issue. So firstly, understand the concept of locus standi. This basically means only the directly affected person or group can approach the courts. But please be logical here. Is it always possible for somebody who is getting affected to approach the court? Not really. Let us say somebody who does not have the knowledge, somebody who is downtrodden, too poor, no knowledge, no understanding, out of fear, various things. Let's assume you go to your house every day and your neighbor next door, the husband beats the wife, or vice versa, whatever, wife beats the husband. In that case, the spouse is not able to approach the court, maybe out of fear, out of shame, whatever reasons. People languishing in jails, they can't approach the courts. Who will approach the court on their behalf? If you say that no, others can't come to me, what's your concern? Is he beating you? Is he beating your girlfriend, your boyfriend? Come on, mind your own business. What kind of logic is this? If somebody is not able to approach the court, is not able to protect their own rights, don't we as citizens, as people of this country, have this duty to also uphold the rights of others? So, Supreme Court slowly and steadily diluted this concept, diluted the idea, meaning now any person with a genuine interest or a legitimate concern about public issues is allowed to approach the court. Anyone with genuine interest, and not just genuine interest, also legitimate concerns about public issues, is allowed to approach the court. Meaning, you may not be the directly impacted party, right? For somebody else, I can now file a case. That case is called public interest litigation. Litigation is a case. Public interest in the interest of public at large, not my personal interest. This is what is called PIL, right? Earlier, only affected parties could file a case. Now, anyone, individual, group, NGO, anybody can approach the court for somebody else also. Clear on this? Like Jolly LLB, like Jai Bhim, examples of people who don't fight a case for themselves but for others. That's the idea of PIL. Are you clear? So now, since Supreme Court has started allowing these things, people are filing cases. There are various examples of PILs in various fields. For example, prison reform. Just to tell you, this is not the very first case, but became the most popular case. And this is normally referred to as the mother of all PILs. Hussain Ara Khatun case of 1980. This case involved around 40,000 people languishing in jails for decades under trials. How could under trial go to court? Somebody else filed a case on their behalf, and then Supreme Court gave a judgment. Under trials in jail, their conditions have to be given bail, or the date of hearing has to be done. This was done in the Hussain Ara Khatun case, 1980. Or in one judgment in PIL, Supreme Court has said, we have to humanize the prison administration, humanizing it, treat the prisoners with decency. Don't ill-treat them. Just because they are in jail, you can't ill-treat them. Or right to fast, quick, speedy trial. Or humane treatment of detainee if the police detains somebody. This case was the DK Basu case, where Supreme Court said that just because you have detained somebody for some hours, you cannot ill-treat them. For example, if let's say you are creating some nuisance on the road with your friends, the police comes, they'll take you to the police station, make you sit there for 6 hours. Now they cannot ill-treat you. You also have this right of decency and respect and dignity. Limiting solitary confinement. Do you remember? Supreme Court in the Shatrughan Chauhan case said that you cannot simply confine people separately. Do you remember this judgment? Shatrughan Chauhan case, back in the mercy petition, President's pardoning power, Article 72, we had discussed this. Or avoiding excessive handcuffing. You cannot handcuff people randomly. No, that is why Supreme Court orders are very clear. If you have to handcuff somebody, there should be a proper permission from the magistrate, or there should be ample evidence to support that the person may abscond if you are not handcuffed. In the movies, you always show when the police comes with a handcuff, they bring the handcuff. That is not actually a norm. It is an exception. Handcuffing is an exception. You can't chain people like animals. It is not allowed. Then some PILs for women, improving the lives of women. For example, there was a case which went to Supreme Court called Vishakha Guidelines case of 1997. So any person who works in the corporate field or any company, there are guidelines which your company has to follow to prevent any kind of sexual harassment at workplace against women. Now we have a law in the country. That law is called Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, after the Nirbhaya case. But since 1997, this is the Supreme Court judgment which has forced every company, every organization to have certain guidelines, a complaint mechanism, an authority in the company who can look into any allegation made by any woman in the company of any sexual harassment, done by Supreme Court judgment. Don't you think it is a task of government to make rules, etc.? Supreme Court did it. Or nutritional and feeding norms. So nutritional and feeding norms for lactating women. PUCL case of 2009. PUCL basically is an NGO called People's Union for Civil Liberties. Inheritance of property rights, Supreme Court judgment. Or regulating the sale of acid. So basically, you must have seen this happening a lot, that when some guy approaches a girl and says, I love you, girl says no, then one guy will definitely, out of every 100 people, one guy will go crazy. His ego gets hurt, and then he'll try to take some revenge and throwing acid on the face of this girl or woman involved. So in the Lakshmi case, Supreme Court gave an order that government has to make rules to regulate the sale of strong acids. Now we have rules in place. So if you want to purchase a concentrated acid, you need to give your ID proof, etc. Otherwise, it can't be purchased. So it has come through Supreme Court judgment. Whose task was it to protect any citizen of this country against such kind of acid attacks? The police. They failed. Supreme Court entered. Activism. PILs. Then separate police lockups for women. So even in those police stations where you have a single lockup, Supreme Court orders are very clear. You cannot keep a male and a female detainee together in the same lockup. It is not allowed. Or no arrest before sunrise, after sunset for women, Bharti Khandar case of 2012. All these are tasks of the government to protect the rights of people, the parliament to make laws. Supreme Court is giving judgments. Child rights, establishing juvenile courts with trained officers. Juvenile, under 18. For kids, we need to have separate courts where trained officers should be there. This was also done in one case called Sheila Barse. Sheila Barse is a social activist. Tell me, whose task is this? Whose task is to ensure that the young kids who are involved in crime, they are treated separately in separate courts? The government, the parliament to make laws. But since you are not doing it, I as Supreme Court have to give a judgment. Sorry. Or preventing child labor in circuses. Now, thankfully, circuses are not allowed comprehensively. Now we see all these big platforms like Book My Show. They also don't have circuses now because it is ill treatment of animals, nothing more. But now you cannot employ kids in circuses. Bachpan Bachao, that Bachpan Bachao Andolan, their case was filed. Again, whose task? This is a task of the executive, the parliament, to make laws to prevent child labor. Supreme Court is interfering because you are not doing a task properly. Or no employment of kids in match factories. Again, Supreme Court judgment, MC Mehta case. MC Mehta, again a very popular social activist. Or not employing kids in carpet making factories. Again, an NGO filed a case. Bandhua Mukti Morcha. All these have come through Supreme Court judgments. Or this very famous case of Vishwa Jagriti Mission, that is preventing ragging. So now in all the schools and colleges, there are guidelines which have to be incorporated for anti-ragging. Anti-ragging helpline is there, all these things are there. Do you know that these guidelines that the colleges enforce now, whether properly or improperly, that is secondary. The guidelines they enforce did not come from government. They came from Supreme Court judgment. Ideally, government's task, parliament's task. See, how when they fail to perform the tasks which ideally they should have performed, the court has to interfere. Activism. Then more examples. Environment. In the field of environment, so many examples are there. The healthy environment, the very famous rural litigation case, the Dehradun quarrying case as we call it, where in this case, Supreme Court went ahead and said that right to healthy environment is a part of Article 21, right to life. Every person has a right to healthy environment. Okay. Then the concept of polluter pays principle, you'll be studying it in environment classes. Or absolute liability principle. Firecracker ban. This was done by Supreme Court in the Arjun Gupta case of 2017. Firecracker ban, right? Or even this Supreme Court judgment that firecrackers should only be bursted through community participation to prevent what? Environmental damage. Or the Bharat Stage 4 plus 6 norms. What is Bharat Stage 4 and 6 norms? So in your environment classes, you'll understand that in our country, we follow some regulations, of course, inspired by the West, to regulate the vehicular emission in our country. So what can be the maximum permissible limit of emission of nitrogen oxides and the sulfur oxides from your vehicle? There's a limit. So engines have to be modified for that. Now, the big problem was government would not impose this on the automobile sector because it would involve the entire automobile industry to revamp its system, its functioning, etc. Right? So government kept quiet. Supreme Court eventually gave a judgment and said, come on, you have to enforce Bharat 6 norms. MC Mehta case 2018. Are you able to see that all these are a part of Supreme Court judgments which have ensured that the areas, all those areas where the government has failed, where the parliament has failed, the Supreme Court does not fail the people. Governance, in the area of governance, anyone who wants to contest elections, all the candidates who want to contest elections, it is mandatory for them to publish their criminal history. Whatever is your criminal history, it is mandatory to publish it. People have to be made aware of it. It is not done by parliament. NGO, PUCL filed a case, Supreme Court judgment. Appointing special investigation teams. Sometimes when the police is lethargic, does not take up a case seriously, the courts direct the government, come on, form a special investigation team. Look at the recent case of Election Commission of India, the appointment of members, Anup Barnwal case. Did we not see this happening when allegations were raised that the judges, the election commissioners, they are largely appointed by the government of India only, so it could be a possible case of biasness. So here what happened? The Supreme Court interfered and said, okay, if you feel there is biasness, we are giving an alternative on how to appoint these people. So how did this come from? It came from what? Supreme Court judgment. Anup Barnwal case of 2023. SIT, I mentioned the full form here of SIT, Special Investigation Teams. Then there was a case in 1997 called the Vineet Narayan case. It is from this case that the appointment of CBI director is done by a group of 3 people: the Prime Minister, the CJI, and LOP Lok Sabha, to prevent the misuse of CBI at the hands of government. Okay, so PUCL is an NGO. You can Google search for the full form of all these things. Nothing here is a unique full form. PUCL stands for People's Union for Civil Liberties. Okay, so many examples. Then some recent examples of activism, how Supreme Court interferes, various high courts interfere to protect the rights of people. Like recently Kerala High Court, it said that because we must have seen the rise in all these cases where people were being bitten by these street dogs, right? The stray dogs in the street. So the Kerala High Court said it is a state's obligation to protect the citizens from ferocious dogs. Or when it comes to acid attack victims, various high courts constantly force the government into giving compensation, right, to these victims. Then Delhi High Court. Delhi High Court recently gave suggestion also to Government of India that why don't you create some kind of public crowdfunding, get money from people only for the treatment of rare diseases. Then just last year in Telangana, the Telangana government cancelled 19 lakh ration cards of people, saying that these people had wrongfully obtained ration card without conducting any kind of study, etc., or any ground check. Supreme Court instructed the government that no, all ration card cancellation has to be done after conducting proper verification. Or Supreme Court in case of Rajasthan, Gujarat. So in case of Rajasthan and Gujarat, these are states wherein you have a lot of potential for solar energy. So when you use solar energy or wind energy of any of such kind, so the electricity has to be transmitted through transmission lines. But because of the transmission lines not being visible from a very far off distance, some birds like the great Indian bustard, lesser floricans, etc., they fly, and because the transmission lines, the wires are not visible to them, they collide and die. Government is silent, no interest. Supreme Court instructed the Gujarat and Rajasthan governments that please install bird diverters. Basically, it's a plastic device which you install on the transmission lines, on the wires. The birds can see that from a far off distance and they change their route. So they don't collide with the transmission wires and they don't lose their lives. Right? So these are all examples of activism. So this is what we say is a need when the government fails to fulfill its obligations, when the parliament fails to fulfill its obligations. I hope now you understand why we need activism, because it may not always be the case that the government does everything perfectly. Sometimes knowingly, sometimes unknowingly. So what are the positive implications of activism? Number one, it prevents undue discretion in administrative decisions. Government cannot take any random decision because they know there is a big boss Supreme Court which will check the constitutional validity of your action. Example. Simple example. Reservation to Marathas. Now the reservation to Marathas was given by the Maharashtra government. Supreme Court cancelled it, saying there is no data, measurable or quantifiable data, to prove that Marathas are backward in any sense in Maharashtra. They are forward in they are leading community in the political life in Maharashtra. Please don't give them a reservation under OBC. That's wrong. Cancellation of this reservation. Your random discretionary behavior will not be tolerated. Follow the rules properly. Number two, it has promoted transparency in governance. I gave the example of how every candidate has to give their declare their criminal history. Electoral candidates declare criminal history. This is in the PUCL case. Or also declare educational qualifications. Abhiram Singh judgment. All these are court judgments. Do you think that our MPs, MLAs have made laws that I am giving all true information? No, 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 no. All that came from Supreme Court order, that if you want to contest elections, people have a right to know what your criminal past was, how many cases are pending against you, what is your degree, education qualification, tell the people. Then governments can shift their responsibilities on the courts. Sometimes, for this, I'll give an example of this movie called Nayak. If you have seen this movie, Nayak, One Day Chief Minister. So in that movie, the Tamil one where Arjun is there, or where Hindi one where Anil Kapoor is there, in the initial part of the movie, when this entire issue happens, when this college student dies and the bus drivers and the conductors are all creating a havoc. So the press reporter, the actor who plays a press reporter, he is shooting everything. He also shoots a small video where the police commissioner is talking to chief minister. Remember this scene? In this scene, the police commissioner is asking CM for orders to lathi charge or what to do. And the CM says, don't do anything. Why? Students are student unions. They help me in getting votes. The bus driver belongs to the caste of my party or my caste. I get their votes. right? The CM says, let them fight, let them shout, they'll fight, shout, cry, get tired, we'll go back home. So just a simple example that the government sometimes knows what is right, what is wrong, but because of backlash, the fear of backlash, they'll say, forget it. Why to take an action? Why should I interfere? Right? So this is what was rightfully shown in that movie. And you can see this everywhere. For example, as a case is going on, same-sex marriage, or even Bharat Stage 6 norms implementation. Why would I as a government show any kind of interest in reforming the entire automobile sector? It will impact my revenue also. Let it be. Then, see, in our country, we have something, just to give a simple example, Article 21. Article 21 is what? So right now I don't know, but it basically means right to life. But Article 21, right to life, does not just mean living. It means so many things now. Living with dignity, against handcuffing, against public hanging, against polluted environment, right to marry somebody of your choice. So many things are a part of your fundamental right to life. How? Supreme Court. They have tried to strike a balance between what has been the constitutional value and the changing circumstances. Something as simple as termination of pregnancy. So, as per the law, pregnant women, married women could terminate pregnancy. Married women could terminate pregnancy. Maybe in 1950s, becoming pregnant outside the wedlock marriage was something unthinkable. But nowadays, it is very common. Not because it's something immoral. It's a very natural human emotion. And because of delayed marriage ages, people in their early 20s, late teens also, mid 20s, they may get pregnant who are not married. But can they not get abortion? The law says no. The Supreme Court modified it, saying why only married women? Times have changed, things have changed. So any woman can get the benefit of this abortion. You modify yourself, you improve yourself. Say 50 years back, live-in relationships were unthinkable. Now it's okay. People do it. And courts also say that equal rights for live-in couples. So see, that's why we always say what was accepted 30 years ago is unthinkable now. What was okay a few years back is something unimaginable. What was not possible yesterday is possible now. We will never be woke enough. There will always be room and scope for more liberty, more progressive behavior. You may feel your parents are so outdated. Your kids will feel your thought is so outdated. We'll always improve. We'll always move towards equality, right? Then it has also helped in checking government inaction, environmental concerns, police reforms, areas of corruption, electoral reforms. In all these areas, when the government is not active, Supreme Court interferes and has played a complementary role with respect to Parliament. So many judgments where Supreme Court gives a judgment, it is just like we feel it's the Parliament's responsibility. Example, Sabrimala. Example, LGBT rights. That is section 377 of IPC, which was modified, right? Or more examples, Vishakha guidelines. So many cases where ideally the Parliament should have made a law, right? But since they did not, for whatever reasons, vote bank politics, lack of understanding, maybe they did not feel the issue was so urgent, Supreme Court ensured that if you do not perform your mandate, I will have to interfere in your area and perform the task for you. Judicial activism. Hence, I hope now you understand the definition of judicial activism. Now, of course, not everything is amazing with activism. There are some problems also. Let's do one thing. Let's end our discussion at this point only. In the next class, we'll discuss some problems with activism, because activism has no problem. The problem is overreach. When you cross that boundary, because then you are undermining the separation of power. For example, just to end our class on this example only, Supreme Court has passed a judgment. People of Tamil Nadu would know this case started there only. The K. Balu case versus Tamil Nadu in 2016, where Supreme Court has said that sale of liquor on national highways within 500 meters range not permitted. What kind of judgment is this? What kind of judgment is this? If I have to purchase some liquor, I'll go 500 meters inside and purchase it. Secondly, what is this non-liquor purchase on national highways? We feel this is based on this belief that people drink and drive and cause accidents, right? Where is the data? Because NCRB data says that 60% cases of deaths that happen are because of overspeeding, not drunken driving. Drunken driving cases are less than 3%. The number of deaths that happened in 2020, 1.33 lakh people died due to road accidents. 3% cases where the case was a drunken driving case. So this makes no sense. Or, simple example, Supreme Court few years back gave a judgment that everybody should stand for the national anthem and the theaters must play the national anthem. Now they modified it that you have to stand up, but theaters need not play it. Why should a national anthem be played in a theater? It's the national anthem, firstly. See, firstly, there is no law in the country which says you have to stand up for the anthem. We still do, right? As a mark of respect. Don't force it. People still do it. We don't need your constitutional patriotism. It's okay. People respect the country, they will stand up for it. Secondly, why do you want the anthem to be played in the theater? It's an anthem. It's not some song. That's why national anthem is not sung. It's performed. It's demonstrated. It has some respect. It has some dignity. You play the anthem. After the anthem, some Imran Hashmi movie is playing. How does it increase the dignity of the anthem? You can't play the anthem at every random place. There is decorum. There is respect. Just like, when you read your religious texts, you can't read them at any random place. There's a decorum and respect to recite those religious verses. Similarly, it's the national anthem. And we don't need the Supreme Court to tell us what is patriotism. If the Home Ministry says, justified. Government says, okay, we'll agree. Who are you to teach us? And is this sufficient patriotism? So sometimes they cross that boundary. Collegium system. Collegium system is a classic example of overreach only. You have denied the executive any role in appointing judges. Is it not overreach? It's overreach. Sometimes they cross the boundary. Limitations have to be drawn, right? That is what is the issue. So issue is not activism. Issue is basically the concept of overreach, the concept of adventurism, the concept of populism, giving verdicts which are people-pleasing in nature. They may not be correct, but I just want to sound more liberal. That is where the problem starts. And we've also seen Supreme Court being completely inactive in various cases. To give you a very, very basic example, in the Ashwini Kumar Upadhyay case which was filed, the petitioner said, we want uniform marriage age amongst all religions. Why is there a difference in the minimum age for marriage? in various regions. Supreme Court, a 3-judge bench, dismissed the petition 20th of February 2023. Why? They say Parliament must decide. But you are deciding other things also. Sometimes Supreme Court is in a hurry to take up rich cases. Arnab Goswami gets date immediately in Supreme Court. Kangana Ranaut gets a date immediately in Supreme Court. Others can't. So we don't really know what are the parameters on which Supreme Court interferes and does not interfere. Issues. Anyway, more on these issues and examples and problems in the next class. That's on Monday. Till then, that's all for me, guys. Jai Hind. Okay, questions now, if we have any. Oh, sorry, class on Tuesday, no class on Monday. Sneha, till now, according to, see, there will always be issues and concerns. Issues, concerns, suggestions. Issues, concerns, suggestions. Your body is all about issues and concerns, advantages, challenges, and your conclusion is suggestions. Go back to your very first PYQ discussion, which we did on, I think, Friday, right? There I had mentioned on what should be a best proper conclusion, suggestions, way forward, a positive frame of mind. Sai Dinesh, were you absent when I said this? On Monday, you have a May Day. Somalia, it is not that easy also. Somalia, ask your lawyer friends here. They will know. First generation lawyers find it very difficult. It is a family generation, 7th generation, 5th generation lawyers. They enjoy and earn money. Shalu, sir, pending cases are those cases where no hearing took place or hearing took place but no final result. Either of these two. Eventually, no final result has come. That's a pending case. Whether hearing took place or not, everything is covered. Pooja, I would not think so that same-sex marriage is an example of overreach. Let's see, though some statements made by D.Y. Chanchud were a bit too woke. We'll discuss them on Tuesday. Sakshi, yes. Examples should be mugged up. You'll have to quote these examples in the answer. Snehlata, yes. Today they have slightly become more lenient with respect to rights being provided, which is very accurate. Yes, Shalu, absolutely. Anand Padmanabhan will discuss Sabarimala later on. Sabarimala judgment has a problem, which is a different kind of problem, which we'll discuss later on. Devansh, that's true, but if things go wrong, then don't you think I also have the right to or also have a duty to uphold the rights of citizens? That's where that line is very fine. When does the Supreme Court cross it is sometimes difficult to decipher. Nandini, Sabarimala will discuss under Article 26, not right now. Ignore it. Sai Dinesh, overreach. I gave some examples. More examples on Tuesday. Yes, Somalia, I read this. Okay, very good. Yes, Abhishek. Yes, it is overreach actually when they constantly interfere and always make CGI a part of everybody. That is overreach. Where we can't get topic-wise mains questions, download all the PYQs, selectively solve the questions, take some effort. Yes, Nandini, government can overrule these decisions. All these things can happen. Gram Nyalaya provision. Where is the Gram Nyalaya provision? Yes, that's true. Sakshi, it is going to be a responsibility. Snehata, now in theaters it is not mandatory. No, it is not mandatory to play the anthem. Don't elaborate these points, just mention these points and give example. That's sufficient, Shalu. Democratic and judicial activism. Sarfuddin, Bangalore. Okay, I believe largely your questions have been addressed. No, Vaishna, that was not overreach. That was okay. I mean, involving stakeholders, justified. Jared, more on Tuesday about this. Jhansi Rani, what is sealed cover? Sealed cover is basically when the government gives any information to Supreme Court and they don't submit it in open court. They give it in a sealed copy. This means the Supreme Court will not reveal the information to public. That's a sealed cover information. Information which only Supreme Court and government will know. Okay. That's all for me, guys. Please revise. We have covered a lot of ground this week. You have 3 days to revise. Revise as many times as you can. And that should be all for me today. Till then, let's meet on Tuesday. Till then, that's all for me. Jai Hind.